To get the latest voting rights and democracy news, subscribe to Democracy Docket's free newsletters. Click in the link in the upper right-hand corner to subscribe now. Welcome, Rakim, to Defending Democracy.
Thanks, Mark. I'm happy to be here.
So, Rakim, you've been a long-time contributor to Democracy Docket, and I cannot tell you how excited I am to have you here talking with me, because you have some really, really well-formed thoughts and opinions about the courts and democracy, as do I. But before we get to those, tell me a little bit about Alliance for Justice, and also how did you get into this work?
Yeah, for sure. So Alliance for Justice has been doing this work for longer than we would like to have been doing it, for over 40 years. It was founded by my predecessor, Nan Aaron, in 1979, just as the Reagan administration was getting going with many of the things we're now seeing come to fruition, unfortunately. I joined the board of the Alliance for Justice. I actually have been inspired by some of my work in law school to think seriously about who was on our courts, as well as what our courts were deciding, and wanted to help out with the effort to put more progressive judges, more movement lawyers on the federal bench. And so was invited to join the board, and shortly thereafter, during our search process, was invited to succeed Nan Aaron, and it's been a great honor.
So let's start from the top. The U.S. Supreme Court. There are lots of problems that we've seen with the court. And, you know, they range from ethics issues to the selection process, you know, the process by which Merrick Garland was not even given a hearing.
Right.
Amy Coney Barrett, Justice Coney Barrett, was put on the court under analogous circumstances at the end of a term. And that's before you even get to the rulings.
Right. Exactly.
Of the court. So when you think about the Supreme Court and its problems, where do you start?
Well, I probably start where most of the public is starting right now, which is the public perception that the rule of law is not rendered in an impartial way. For those of us who've been close watchers of the court, we've been concerned about that for a very long time. I sometimes do a timeline where I say AFJ is founded in 1979, ACS is founded in 2000, Demand Justice is founded in 2016, to show the kind of growing agitation that the public has felt about the composition of the court and its decision making. But even within that context, we've reached a fever pitch because of how the justices conduct themselves. So Justice Alito is very fond of saying, I don't even think that Congress has the authority to regulate the Supreme Court. Where do they get that right? And that just totally breaks from our precedent and our tradition, where the branches, of course, check one another. And so we've reached a Supreme Court era. It's something that agitates all of us because it doesn't comport with how we understand our government to work.
And you mentioned Justice Alito, who interestingly seems to be in like a letter writing campaign with the Wall Street
Right.
Journal editorial board, which is a little unusual for a justice. The other justice that has probably attracted the most attention right now on the ethics front has been Justice Clarence Thomas. And I wonder how you see him fitting into Alliance for Justice and your own views of the court.
Sure. Well, we've said a corrupt court is as good as no court at all. We've run a very large campaign calling on Justice Thomas to resign, in part because the ethics violation is just so plainly obvious. I mean, the example I often would use, this was during NBA playoff season, so now people can make their NFL analogy. But I basically said, if you knew that one of the refs was going out for drinks with the other team's owner, whether or not that was actually affecting how the ref called the game, you might just have problems with it if you were the other team. You know, you could reasonably say, that doesn't feel right. It somehow calls into question the integrity of the game. Well, the same is true with regard to the rulings that the court offers right now. And I think that the public writ large is right to be suspicious of what happens at this court. Again, Justice Thomas and his defenders have said he's a man of great integrity. No one can influence his rulings. That's not really the point. The point is that there's the appearance of impropriety, and that appearance erodes the very foundations of our democracy because it cuts at the rule of law.
Yeah, I think that's a really interesting point. There are different judicial systems and legal systems around the world, and the system that we have is sometimes referred to as an adversarial system, and it
Mhm.
assumes a few basic things. The first is that you have adversaries in a proceeding, right? You have an actual dispute between the parties, and each party has an incentive to
Mhm.
win the case, right? Within the rules and the law and the procedures, of course, they have an incentive to advocate for their position. But
Right.
the other part is that the judges need to be not connected to either adversary, right?
Right.
Like that's what makes the adversarial system work. And so, as you point out, whether in fact the rulings would be different or not is actually not foundational to the adversarial system. The adversarial system assumes that you have the umpire, as the Chief Justice once referred to
Mhm.
himself and others, who has no connection to either team.
Exactly. Exactly. I mean, you might even think about it in narrower terms, maybe a boxing analogy, right? So if the ref for one player, or we at least think that for one of the boxers, the ref is saying that certain shots are below the belt, but for the other boxer, not quite calling it the same way, because again, they're drinking buddies afterwards or before, or because the ref has somehow invested financially in the outcome of the match. That would obviously lead people to say, this might be rigged.
Right. But this is, I think, like I said, I think you really hit on something. That's true. Even if the better boxer wins the
Yes.
bout.
Yes, it doesn't matter who wins the bout, and it doesn't matter if the ref is actually impartial. Like, in fact, you look back and you say, you know what, there's nothing untoward about that. But that's the kind of corrective that it seems that Justice Alito and others want us to apply to the court's actions, which is, well, ignore everything that's happening around the court, ignore all of their relationships, assess whether or not you think the decisions or the rulings would somehow be different if, in fact, these relationships didn't exist. And to your point, that's not the test. The test is whether or not at the time the decision is being made, you have any reason to think, maybe this person ought not be ruling in this case.
Okay, so what do we do about this? There are lots of ideas kicking around about Supreme Court reform, everything from term limits to an ethics code to different selection processes. What's the solution here?
There are a lot of good solutions that people are floating. As we said, Justice Thomas should just resign. Let's start there, and we'll be happy to move. We'll be happy to move on to other things. But I think the code of ethics is an obvious reform. In fact, as I often tell folks, every current judge on that court, except for Justice Kagan, was bound by the former judicial code of ethics because they sat on the lower courts and they didn't protest or scream that this was an undue intrusion into the judicial branch. They abided by them. And so, at the very least, the same code of ethics that applies to the Court of Appeals and the district courts should apply to the Supreme Court. And perhaps an even more enhanced code, given the fact that when its rulings blanket the entire nation. But the thing that I've really come around to, I was just thinking about it this week in preparation for this call. You might have thought would have thought about it earlier, but was term limits.
Mm-hmm.
And it was in part because I initially had the feeling that term limits, maybe they were unconstitutional, maybe they intruded too much on the third branch of government. It does say during a term of good service. But then I thought back and realized that, you know, George Washington, whatever our assessment of him as a president, set a pretty good precedent where he just said, you just don't kind of do this for life, right? None of us should do this for life. So I'm going to do it for 2 terms, and that should be sufficient. Now, we haven't been able to encourage Congress to do the same, but if you think that the founder of the country, who was supposed to be, the wisest man, the man who had the greatest incentives in some way to turn this country into what he had seen in Europe and anoint himself a king, said, you know what? The opposite of doing that is to impose some self-restraint. I'm going to leave after 2 terms. The only president who exceeded that was FDR. And then what did the Congress do? Say,
Mm-hmm.
no, 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 no. This 2 terms idea was a good one. And so I think the public ought to start there. Let's not look at the current controversies around the Supreme Court. Let's just ask ourselves for a moment, for the sake of our democracy, do we really want any person, and certainly any group of people, to be in the same position for several generations, potentially, at least one full generation. And you might say, on the one hand, well, the law moves slowly, it builds over time, so maybe they should be there for longer than you would have a president serve. But the current bills account for that. I think folks are suggesting 18-year terms, so almost a generation, long enough to see the law develop in a way that would make it predictable and again undergird some of the central foundations of what we do, but not too long that the folks would begin to become comfortable, as Justice Thomas has, and perhaps begin to use the institution for their own means. And of course, in our early history, most justices did not serve until their last breath.
Yeah, absolutely. So let's turn to some substance in the Supreme Court. You are, in addition to a scholar and a close studier of the Supreme Court as an institution, you are also a scholar and a close studier of its substantive decisions, particularly around democracy. And last term, there was a lot going on. I mean, there was a lot going on. There were two big democracy cases that came out better than people feared.
Yep.
But there were a lot of other cases that turned out terribly. I mean, let's not,
Right.
there was a part of me that when those cases came out, I was like, well, hold on, everybody. There's still a few weeks left.
Right.
Yeah,
Right.
right.
Exactly.
Like, how do you sort it all out? I mean, you have Moore v. Harper, which was the ISL fringe theory that got rejected. You had Allen v. Milligan, which was frankly little more than the reaffirmation of the voting rights jurisprudence that existed since the mid-1980s, but people were real worried about that.
Yeah.
Then you have the student debt and the affirmative action and the 303 creative case. Like, you got all of this swirling about. Like, how do you, now that you've had a few months to look, to catch your breath, like, how do you think about the term that was?
So a friend of mine has an analogy. It's not mine, and I'd love to take ownership for it because it accurately captured how I feel about the court. But describe this as sort of being in an abusive relationship where you're happy, of course, that the abuser doesn't do the worst possible thing to you, but you know that more bad things are coming. And that really feels like what the court is engaged with regard to our democracy. The 6 conservative justices have a very different view than the majority of the country, views hatched in the 1980s. And I wasn't born until late into the 1980s, so I can't say I know a whole lot about it, but I've never desired to go back there at all. And yet that seems to be where their jurisprudence was born, and where the ideas were born, and the exact ideas that they're trying to bring into the 21st century. So yes, we can feel good that certain parts of our longstanding jurisprudence survived this assault, but we can be confident that in future terms, other pieces of our jurisprudence won't survive.
Yes, I can tell you as someone who was in college in the 1980s, you may be being charitable about how far back their jurisprudence goes. I mean, in the 1980s, you still had a ban on corporate independent expenditures. That wasn't
right.
The case that Citizens United overturned was in the 1980s. In the 1980s, you had more or less a bipartisan consensus in Congress for the Voting Rights Act. Right. And the Supreme Court had upheld Section 2 and Section 5. So my fear, Rakim, is that we're actually regressing further back, and it makes me sort of ask a question that, when I became a lawyer, I never thought I'd ever ask, someone like you, but I will, which is, are we devolving into a system where the court really reflects the political partisan divide in the country? And there's really just not a lot of, you mentioned the six justices. They all have one thing in common, right? The party of who they were appointed by. And that was not true always. That wasn't true even with Justice Kennedy, who was, was a conservative, but it was not true with David Souter. It was not true, right, with a number of people. Do you think that that's where we've evolved to, and is that just a permanent state of affairs?
Well, I hope it's not a permanent state of affairs, but yes, that is where we've evolved to. I remember being on strict scrutiny, and one of the things that I shared with that audience was, just think about the phrase "no more suitors." For those of us who've watched the court for a good long time, you'll know that was the Federalist Society's sort of chant with regard to the judicial selection process, making sure that they had greater control and influence so that they didn't end up with any, as they viewed them, turncoats like Justice Souter, that is, independent thinking jurists who might very well assess the law and the facts and come to decisions and outcomes that were different than the party orthodoxy. And as I said then, they were effective in securing exactly that regime. Remember that before Samuel Alito was nominated to the bench, President Bush nominated Harriet Miers. Mm-hmm. And it was Robert Bork and a series of other prominent conservatives who said that the conservative legal movement would have failed if Harriet Miers was selected to serve on the Supreme Court. Now, I don't know anything about Harriet Miers' jurisprudence, but given that she was hanging out with George Bush, I'm sure it's not the jurisprudence that you and I would have approved. And yet even that was not secure enough for them, so that they ended up with Samuel Alito, who had been a dyed-in-the-wool conservative, served in the Reagan administration and Bush administration Justice Departments, and only he could serve. So long as that's the case, so long as Federalist Society membership is essentially a requirement for being appointed to a circuit court or the Supreme Court of the United States, so yes, your fears have been realized.
So we've spent a lot of time so far talking about the Supreme Court, which is where most Americans focus their time and attention. But I have found some of the most compelling stuff you've written and spoken about, including pieces you've written on Democracy Docket, about a sea shift in the composition of the rest of the federal judiciary. And just so that listeners are sort of focused on this, the federal courts hear hundreds of thousands of cases a year, literally, 300,000-400,000 cases a year, I think. The courts of appeals hear, thousands or tens of thousands of cases. The Supreme Court hears like 60 or 70, right? So most federal court cases are resolved by district court judges and to a lesser extent, but significant extent, Court of Appeals judges, not the U.S. Supreme Court. And there's been a lot going on there with the type of judges that President Biden has nominated, which, like I said, you've written about. And can you talk about that shift and why you think it's so significant?
Yeah, absolutely. So most folks know that Mitch McConnell prevented President Obama from seating Merrick Garland. Fewer people, but everyone really should know that Mitch McConnell and Donald Trump then embarked on a crusade to transform the federal judiciary and made 230 plus appointments to our federal courts. So if you're afraid of the 3 justices he appointed, wait till you see the other folks who escaped the same level of public scrutiny, which include people like Matthew Kacsmaryk, who, of course, attempted to ban mifepristone. And so when I joined, there was a large-scale effort among the progressive movement to really get the Biden administration to be laser-focused on reversing those trends. Because what we were seeing was that a decision would come out of the Supreme Court, and no matter how conservative it was a principled decision that then you would think could be applied in some way throughout the rest of the federal judiciary. But instead, what was happening was that decision would metastasize into something even more Frankensteinish, even more ghoulish, as it was processed through the federal courts, because, as we were talking about earlier, all of these folks know each other and have existed in Federalist circles for a long time, Federalist Society circles for a long time, and have hatched these weird and strange theories that now they get to work on. It's like the strangest, sandbox in the land, right? All across the United States. So we knew something had to be done about that. And the president and the Senate have really been remarkable in trying to transform the judiciary into something that Americans can trust again. And so what does that look like? It's looked like over 140 federal appointments in, call this, month 30 or so of the administration. They've continued to set records, but most importantly, it's not just the number of people that they've been appointing, but the quality of the judges. So they've appointed people like Dale Ho and Nusrat Chowdhury, the first ACLU lawyers to come from the ACLU to the federal bench since RBG. Just to contextualize for people, it goes a long way back since we've been able to do something like that. Great champions like Jennifer Sung, who was a labor activist, Holly Thomas, who was a civil rights activist, Myrna Perez, who worked for the Brennan Centers Voting Rights Project led that project, in fact. Beth Robinson, who argued the same-sex marriage case in Vermont. And so the president and the Senate have really been attentive to making sure that the kinds of lawyers who represent the best of our Constitution are now serving on our federal bench.
Yeah, and I think that one of the mistakes that sometimes the media makes is they focus on the lack of educational diversity in the courts, and by the way, that's not a mistake. I mean, like, there is a lack of educational diversity.
That's right.
But one of the things that's really striking about the judges that that President Biden has nominated and that have been confirmed is that, they're not the law school to big law associates to partners representing, ExxonMobil, to the federal bench pipeline. Yeah. You know what I mean? They're many of them have the same credentials. They went to Harvard, Yale, the other,
right.
Elite law schools, but they have very, very different paths to the bench that I think, really gives them a different perspective than, went to AmLaw 100 law firm. So can you talk about that, the importance of that difference of perspective that you gain not being in a big corporate law firm?
Yeah, for sure. I'll try to be simple in describing this. When I clerked for Willie Fletcher on the Ninth Circuit, Judge Fletcher had come from Berkeley Law School, and he was an expert in federal courts. And what I observed on that court was that his colleagues sometimes would defer to him and seek his expertise as a federal courts expert. Makes a lot of sense. He's someone who studied that area of law deeply. Even though you become a judge, it's not the case that you have expertise over all areas of law, admiralty, environmental, civil rights, and so forth. And so you look to the strengths of your colleagues in order to enrich, to get it right in the first instance, and to enrich that body of law. Well, historically, we have limited the kinds of people who could serve on the federal bench to largely prosecutors and government attorneys of one kind. Excuse me, I'll rephrase that. Prosecutors and folks who had served in corporate law. And so what were we lacking? Well, we were lacking folks who had experience representing labor unions or representing workers, even though that's a huge area of law for us. We lacked people who had been working to protect our environment, even though the Clean Air Act and the Clean Water Act and the National Forest Management Act, I mean, these are, again, huge areas of law that require development. And I could go on and on, reproductive rights being a key one. Obviously, it's front and center in many of the court battles that we've seen over the last 2 decades and will continue to be. There were virtually no lawyers on the federal bench who had ever served in a capacity of representing someone who was trying to protect their reproductive rights until just recently with Julie Rinkleman. And so as a consequence, as I view it, all of those areas of law weren't enriched in the same way. They weren't made stronger. They weren't made more compelling. They weren't made to serve our democracy. Where the Biden administration has really succeeded is they've looked out across the legal landscape and looked at all of the genius that exists in all the different areas of law and said, how can we draw that into our federal judiciary so that, again, the law is made better and more reflective of what we want in our democracy?
Yeah, President Biden deserves a lot of credit. Senate Democrats, as you point out, have done a remarkable job in confirming these judges. Senator Schumer, the majority leader, deserves a lot of credit for that. There is one weird or old, I think old, maybe you're going to tell me not old. I always assume weird things in the Senate are old.
Yeah.
But there's one unusual, shall we say, process that I became recently aware of. I'm embarrassed to say, because I'm not an expert in Senate procedure.
Sure.
I became aware of it because the Congressional Black Caucus came out and said that we need to end what is called the blue slip process. Can you just, for our audience who probably has never heard of the blue slip process and just heard you talk about the successes of 140 plus judges, can you explain and help people sort out what this controversy is and what's going on?
Yeah, happy to. So people should think of the blue slip merely as a mini filibuster. That's the way I
Hmm.
like to put it. So when the president wants to nominate a judge to a district court or circuit court, the Senate has a procedure that essentially allows that senator to decide whether or not they're going to filibuster the appointment. If they want to filibuster the appointment, they withhold their blue slip. There's no real slip out there, just like the filibuster
I was
doesn't
going to ask if there was a real
exist.
piece of paper that was blue.
I've not seen it. I wish there was, right? Because at least then we could collect them and, create an art installation or something about obstruction. But no, there's no real blue slip. But so they can withhold their consent and say, no, I don't want this nominee to proceed, or they can offer their consent, which was returning the blue slip. And so, though the president and Senate Democrats have been remarkably successful in advancing all sorts of nominees, the kinds that we were describing, they've largely been able to do so in quote unquote blue states, where there are blue state senators, because those senators are aligned with the White House. So the White House makes a nomination and they return the blue slip and say this person can proceed. So take New York, for example. Senator Schumer and Senator Gillibrand have been remarkably successful in filling the vacancies there because they returned the blue slips after having been in consultation with the White House. On the other hand, if you look at states like Florida and states like Texas, this gets back to what the Congressional Black Caucus is so concerned about. States throughout the South where you have red state senators, Republican senators, those senators are unwilling to return their blue slips. And as a consequence, the president has not been able to nominate and confirm judges to those circuits and district courts. Now, you might ask, well, this is the constitutional authority of the president. What do you mean he can't nominate and confirm them? Well, again, this is an old Senate procedure, and so Senator Durbin has taken the position that he would like to respect the procedure to the extent possible while trying to ensure that it hasn't been abused. And so folks like the Congressional Black Caucus and folks like us have really been saying to Senator Durbin, one of the sites of abuse is to not return the blue slip for anybody under any circumstance.
And it is only the senator's home state judges, right?
Yes.
So it's Tommy Tuberville preventing judges in Alabama. It's not Tommy
Correct.
Tuberville preventing judges everywhere, which I'm sure
exactly
if he could, he would.
And this is why it was so important to the CBC, I should say, because, of course, many of us, I've had these conversations as well. For example, my family left South Carolina, Alabama, and North Carolina and moved to New York. So now I live in a place where my senator is returning the blue slip. But I still have family members who live in Alabama, North Carolina, and South Carolina, where senators are not returning their blue slips. And as a consequence, this is an area you know well. You're an expert in, which is voting rights, where you need 3-judge district panels in order to make major decisions, like in the Allen v. Milligan case. And largely what we have are Republican stacked courts making decisions on these voting rights cases. Now, sometimes they get it right, but it's certainly the case that many of us would like to see more judges, again, who have experiences protecting voting rights on those courts, and we're not able to achieve that with the blue slip process in place.
So you mentioned your family's from South Carolina. Next term, we will see a case in the U.S. Supreme Court out of South Carolina, a very, very important racial gerrymandering case that the court has agreed to hear. I'm very concerned for people who want to know that the Supreme Court has decided that the Supreme Court scheduled oral arguments. Usually, even the conservative justices on the U.S. Supreme Court uphold lower court rulings that find something to be a racial gerrymander, but of course, we'll see what happens there. But before we leave the topic of courts, we've spent the entire show talking about federal courts.
Yeah.
And meanwhile, what we have seen in state courts has been very much a mixed bag. We have seen some very courageous and innovative state courts, and yet where that movement takes foot, we have seen the Republicans now in Wisconsin, after a judicial election there, try to thwart the will of the voters by impeaching a state justice who has literally not yet ruled. So
right.
Justice Protasiewicz was elected in a landslide. She has literally not ruled in a case, and the Wisconsin legislature is threatening to impeach her. We saw the North Carolina legislature, after Republicans took control, immediately roll back a whole bunch of voting rights decisions.
Right.
How do you and Alliance for Justice, how do you all think about, I know there are a lot of them, but how do you think about the state court systems?
Yeah. Well, as you know, the state courts hear over 95% of cases. The Brennan Center is a great colleague in this for people who are interested. They have a great state courts report, as do we. But hear 95% of cases, and most things that concern everyday Americans are decided in their state courts. You know, most criminal justice matters, most property matters. So, for family court, for instance, and so we're very attentive to the ways in which the state Supreme Courts can allow us to, as Justice Brandeis once said, experiment with democracy in different places, have different kinds of rulings that allow us to, again, escape the abusive relationship that we have with the Supreme Court and imagine a different reality, a different set of circumstances. And so right after the Dobbs decision, you saw all across the country state Supreme Courts affirming the right of women and pregnant people to choose what to do with their bodies. And that was, of course, a very invigorating moment in spite of the national disaster wrought by the Supreme Court. With all that said, one of the things that I look at as, again, I was preparing for this interview, is we are just in crazy town. I mean, with regard to how, we just are, right? I mean, with regard to how Democrats and progressives approach courts and Republicans and conservatives approach courts. So we ask at the federal level for a code of ethics because guess what? As Jamie Raskin says, sugar daddies are flying justices around the country, right? Like actual documented things. You know, Justice Thomas has now re-released his disclosures and it confirms everything that ProPublica said he was doing, right? So we say, I don't know, how about a code of ethics? How about term limits? Contrast that with the Republican legislature, and we can't get that. Sorry, everybody should be clear. We can't get those things. Contrast that with the Republican legislatures in North Carolina and Wisconsin, who are trying to impeach their justices or remove them from the bench because in the case of North Carolina, Justice Anita Earl said there's a thing called implicit bias and we're all subject to it. They said, you got to go. You can't even say that. And then Justice Persewich in Wisconsin, as you said, has not even ruled on anything. And by the way, serves on a court with two other conservative justices who have said that homosexuality is equivalent to bestiality, who have said that abortion rights are like killing your own flesh. I mean, have stated very clear views on matters that come before their court. But is this a blanket sort of impeachment effort to say we don't want any of our justices to say anything like this? Or is this just McConnell light, or McConnell sort of blasted down to Wisconsin, where you say there's something on the books that we could use that would allow us to continue to control the court? And so given the example that Mitch McConnell has set at the federal level, we shouldn't be surprised that state legislatures around the country are beginning to use similar kinds of tools and tactics, all again unjustly, all again without due moderation or fair consideration to what the rule is actually supposed to do, to limit the ability of their courts to be free and independent.
Yeah, it is, as you say, crazy town. I mean, all of it is crazy. And I think if we had gone back 10 years and described this world to people, they wouldn't believe it. For what it's worth, Anita Earl is one of the giants and a absolute towering figure in the area of voting rights. My pick for the next Supreme Court of the United States vacancy. So not that I get a vote, but she would be an excellent selection.
Yeah, I think everybody would agree with that.
Rakim Brooks, thank you so much for joining today. You are one of my heroes in your fight at Alliance for Justice. I read a lot about democracy. I never, ever, ever miss reading what you write on Democracy Docket and elsewhere. You are an absolute treasure for the progressive movement and for democracy. So thank you for joining us today.
No, thank you, Mark, and thank you for all that you do for democracy. Your ability to win in court is one of the things that continues to give me faith that our court system hasn't entirely collapsed.
Well, thank you very much. Thanks for listening to Defending Democracy. You can find all the cases and articles we mentioned today linked in the description of this episode. If you enjoyed today's episode, please leave us a review. And to find out more and stay up to date on the latest voting rights and election news, visit democracydocket.com and subscribe to our daily and weekly newsletters. We'll see you next time. Today's episode was produced by Paige Moskowitz and Gabby Corporal. It was edited by Paige Moskowitz. Defending Democracy is a production of Democracy Docket LLC.